A section-by-section walkthrough of California Form FL-300, the Request for Order, RFO, used to ask for new orders or change existing orders while a family law case is open, including required attachments and service rules. What is Form FL-300? Form FL-300 is the California Judicial Council form titled Request for Order. It is used within an existing family law case, dissolution, legal separation, parentage, or a domestic violence case with related family law issues, to ask the court to make a new order on an issue that has not yet been decided, change or terminate an order the court already made. Filing FL-300 puts the issue in front of a judge and sets a hearing date. It is a separate step from opening the case itself, which is why it is filed on its own, after the initial petition or response, whenever a request comes up. New orders versus modifying existing orders. FL-300 covers two different situations, and it is worth being clear about which one applies to you. Requesting new orders. If an issue, such as custody, visitation, or support, has never been addressed by a court order in your case, FL-300 is how you ask the court to decide it for the first time. This is common early in a case, before a full judgment resolves every issue, when one party needs a temporary order in the meantime. Requesting to modify existing orders. If the court already made an order and your circumstances have changed, FL-300 is also how you ask the court to change or end that order. Courts generally expect you to describe what has changed since the last order was made and why the change supports a new outcome. Simply disagreeing with an order that already exists is usually not enough on its own. The declaration needs to explain the change in circumstances. What you can ask for on FL-300. FL-300 is a general-purpose form, so it is used for a wide range of requests including temporary child custody and visitation, parenting time orders, child support, including a new order or a change to an existing one, spousal support, including a new order or a change to an existing one, attorney's fees and costs, property control orders and other financial matters while the case is pending, other requests permitted under California family law. You can request more than one type of order on a single FL-300 if the issues are related, rather than filing a separate request for each one. Emergency ex parte orders. Most FL-300 requests go through the regular process. You file, serve the other party, and both sides are heard at a scheduled hearing. In situations where waiting for that regular hearing date could cause real harm, such as an immediate risk to a child's safety, FL-300 also supports an ex parte request for temporary emergency orders on shortened notice. Ex parte requests are held to a high standard. Courts expect a genuine showing of urgency and immediate need, not simply a preference for a faster hearing. If you believe your situation may qualify, confirm the specific requirements and shortened notice rules with your County Superior Court Self-Help Center. Section-by-section walkthrough of FL-300. Here is what you will actually fill in on the form itself. Case information. At the top, you will enter the county case number and the names of the parties, matching how they appear on the existing case. Type of hearing. You will indicate whether you are requesting a regular hearing or an emergency ex parte hearing, along with the date and time once one is assigned or requested. Orders requested. This is the core of the form. You will check boxes for each type of order you are requesting, such as child custody, visitation, child support, spousal support, attorney's fees, or other relief, and briefly describe what you are asking for under each one. Facts supporting the request. FL-300 asks you to state the facts that support your request. Because the space on the form itself is limited, this is almost always where you reference an attached declaration rather than writing the full explanation directly on the form. Time for service. You will indicate how you plan to have the other party served with the request for order, which affects how much notice they receive before the hearing. The supporting declaration. A request for order is rarely persuasive on the form alone. Courts expect the facts behind your request to be laid out in a declaration, which is your written, signed statement of what happened and why you are asking for what you are asking for. You generally attach this declaration in one of two ways. Form MC-031, Attached Declaration, a general-purpose declaration form used across California courts. A typed declaration formatted to your court's requirements, such as numbered lines and proper caption information, if you prefer to write it out yourself. Whichever format you use, keep the declaration factual and specific. Common attachments to FL-300. Beyond the declaration, what else you attach depends on what you are requesting. Child custody or visitation orders, child support, spousal support or attorney's fees, and any request. Form FL-311 walks the court through the specific custody and visitation schedule you are proposing. Form FL-150 gives the court the financial picture it needs before ruling on support or fees. If you have not yet completed your financial disclosure, see our companion guide, How to Fill Out Form FL-150. If your request involves custody or visitation, it also helps to understand how California approaches these decisions generally before you describe your proposed schedule. See California Child Custody Laws explained for that background. Serving the other party before the hearing. Filing FL-300 with the court clerk is not the last step. After filing, you generally must have the other party served with the completed request for order, FL-300, your supporting declaration, any attachments such as FL-311 or FL-150, any blank response forms required by your local court rules. Service must generally happen by someone over 18 who is not a party to the case, within the time required before your hearing date under California law and your county's local rules. If service is not completed properly and on time, the court may not be able to rule on your request at the scheduled hearing, which can delay the outcome you are asking for. Common mistakes to avoid. Filing FL-300 without an attached declaration explaining the facts behind the request. Requesting support or attorney's fees without attaching a current FL-150. Requesting a custody or visitation change without attaching FL-311 or describing the proposed schedule clearly. Missing the service deadline, which can push the hearing or prevent the court from ruling that day. Treating FL-300 as a place to argue rather than to state facts, especially in the declaration. Forgetting to describe what has changed when asking to modify an existing order rather than just restating disagreement with it. If keeping track of all of this by hand feels like a lot, that is exactly what Virdix is built for. The wizard at Virdix.co walks you through these same questions in plain language and prepares your FL-300 for you. Virdix is a document preparation service, not a law firm, so this is not legal advice, but it can help make sure your paperwork is complete and consistent from the start.